Hello friends, in the series on the income tax cases, today we will discuss the case of Assistant Commissioner of Income Tax versus Pradip Overseas Limited. This case has been reported in 107 ITR Tribunal, short note 60. The matter has been decided by Ahmedabad ITAT C bench and the date of the judgment is 4th October 2023. In this case, 2 points were concluded by the Income Tax Tribunal. First point was that when the order is made by the Settlement Commission for an assessment year, that order is final. And the second thing is that when the resolution plan in case of insolvency bankruptcy code is approved by the sundry creditors and simultaneously approved by the NCLT, and if the central government do not get any place in that waterfall of the liabilities, or in other words, if the income tax department does not have its bite in that resolution plan, then in that case the department cannot recover that amount by resorting to any other action. In the present case, the assessee filed Settlement Commission application before the Settlement Commission under section 245C subsection 1, and the settlement order was passed by the Settlement Commission under section 245D subsection 4 for the assessment year 2006-07 and for the assessment year 12-13. The department filed miscellaneous application before the Settlement Commission for revising its order, which was not entertained by the Settlement Commission. So the department was feeling a little bit suffocated, so the department issued the notice under section 148 on the allegation of inflated purchases by the assessee for the assessment year 12-13, and accordingly the assessment was made. When the assessee moved to the CIT appeal observed that the resolution plan has been approved by the creditors, which has been approved by the NCLT, and since the assessee was under IBC proceedings and the department do not get any place in the waterfall of the creditors, so in that case the department does not have any option just to relax and forgive his liability. And accordingly the CIT appeal deleted the demand created by the assessing officer under section 147 read with section 148. The department moved to the ITAT and the ITAT also upheld the order of the Commissioner of Income Tax Appeals and said that once the Settlement Commission has passed the order for any assessment year, so it means that all the issues for that assessment year is now settled and the department cannot reopen the assessment under section 147 for that assessment year. And secondly, the ITAT also commented upon that in the present case, since the assessee was under the IBC proceedings and the resolution plan which has been approved by the Committee of Creditors and by the NCLT, and since the central government do not get any place in the list of creditors, so in that case the liability of the assessee towards the central government in the form of income tax also get extinguished. So whatever the demand has been created by the assessing officer by issuing the notice under section 148 and by passing the order under section 147 was not valid in the eyes of the law, and the ITAT deleted that addition which was made by the assessing officer after the order of the Settlement Commission for the assessment year 12-13 on the basis of allegation of inflated purchases. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Pradip Overseas Limited, and this case has been reported in 107 ITR Tribunal, short note 60. The matter has been decided by Ahmedabad ITAT C bench and the date of the judgment is 4th October 2023. Thank you, friends.